Terms of the contract. In this short video, we will look closely at the various types of terms that can be included in a contract. The terms of the contract are the specific details of the agreement, including each party's rights and obligations. Broadly speaking, there are two types of contractual term. The first type of contractual term is the express terms agreed by the parties. The second type of contractual term are the implied terms. Terms can be implied by the court and by legislation. We will now consider each of these three types of term. So the first type of term is the express terms of the contract. These are the terms that are expressly or explicitly negotiated and agreed upon by the parties. These express terms may be set out in a written contract. It's important to note that if a term is in a written contract that has been signed by the parties, it is a binding and enforceable term of the contract, even if one of the parties has not actually read and understood the written contract. In Lestrange and Groscaux from 1934, Lestrange agreed to purchase a cigarette vending machine from Groscaux. The written contract contained the following term: "This agreement contains all the terms and conditions under which I agree to purchase the machine specified above, and any express or implied condition, statement, or warranty, statutory or otherwise, not stated herein is hereby excluded." Lestrange signed the contract without actually reading it. The machine didn't work properly, and Lestrange sued Groscaux for breach of contract, namely breach of the implied term that the machine would be reasonably fit for the purpose for which it was bought. The court decided that Lestrange was bound by the contract, including the term that excluded the operation of the implied conditions and warranties. The fact that Lestrange had not read the contract was irrelevant. By signing the contract, he was deemed to have agreed to all of the written terms of the contract. And that is an important point for you to note. When you sign a written contract, you are deemed to have read and understood and agreed to all of the terms in that written contract, even if you haven't actually read them. As we know, most of the contracts that we make on a daily basis are not actually set down in writing and signed by the parties. So how then do terms get incorporated into these types of contracts? A statement that is not contained in a written and signed contract will still be an express term of the contract if the other party is given reasonable notice of the statement before the contract is formed, and this is in fact the way in which many businesses incorporate terms into the contracts that they make with their customers. In Ollie and Marlborough Court from 1949, Mr. and Mrs. Ollie checked into the Marlborough Court Hotel. When they went up to their room and closed the door, they saw this sign on the back of the door: "The proprietors will not hold themselves responsible for articles lost or stolen unless handed to the manageress for safe custody." When Mrs. Ollie's jewellery was stolen from her room, she sought compensation from the hotel, and of course the hotel sought to rely upon this statement. The question for the court then was whether this statement on the back of the door was part of the contract between the Ollies and the Marlborough Court Hotel. The court pointed out that the contract between the Ollies and the Marlborough Court Hotel was formed when they checked in, which means that by the time they saw this sign on the door, it was too late. The contract had already been formed, and so this sign was not a term of the contract, and Mrs. Ollie was entitled to compensation from the hotel. In addition to the terms expressly agreed upon by the parties, terms may also be implied into the contract by the court. Courts are frequently willing to imply a term into a settled contract in order to fill the gaps. There are certain requirements that need to be satisfied. The term must be reasonable and fair, it must be necessary to make the contract viable, it must be so obvious that it goes without saying, it must be able to be clearly expressed, and it must be consistent with the expressed terms. As long as all 5 requirements are satisfied, the court will be willing to imply an additional term into the contract. This is often necessary because when we negotiate contracts, we don't always cover every single eventuality, but that's okay. If necessary, the court will find that an implied term exists within the contract. One particular type of term that the courts have recently been willing to imply into contracts are terms relating to good faith on the part of the parties. In Burger King and Hungry Jack's from 2001, Hungry Jack's was the Australian franchisee of Burger King Corporation in the United States. Burger King wished to terminate the franchise contract Burger King refused to approve a number of new sub-franchise outlets requested by Hungry Jack's, and then terminated the contract on the grounds that Hungry Jack's had failed to open the required number of new sub-franchise outlets. The court decided that Burger King had breached the implied duty of good faith. Burger King was obliged to exercise its powers under the contract, including the power to approve new sub-franchise outlets honestly and reasonably rather than for an extraneous purpose, in this case to force Hungry Jack's into breach of contract. Courts are also willing to imply into the contract a term of which the parties are deemed to be aware as a result of prior dealings. Rather than enter into a single contract, businesses often enter into a series of contracts with the same person. So, for example, a business may regularly order supplies from a particular supplier every month, month after month. In those situations, the terms of the earlier contracts are implied into the later contracts, even if they are not expressly negotiated or agreed upon. A case that illustrates this principle is Balmain New Ferry Company and Robertson from 1906. Mr. Robertson was a barrister who wished to catch a ferry from Sydney to Balmain. The way things were set up then, there were turnstiles requiring the payment of 1 penny for the trip, located at the Sydney wharf but not at any of the other wharves. If you wanted to catch the ferry from Sydney to Balmain, you paid 1 penny at the Sydney end, and then you went through the turnstile and you got onto the ferry. If you were, however, travelling from Balmain to Sydney, you simply jumped on the ferry at the Balmain end without paying anything, but when you got to the Sydney ferry stop, you had to pay 1 penny to exit the wharf and go through the turnstile. After paying 1 penny at the Sydney end to get on the ferry to Balmain, Mr. Robertson realised that he'd missed the ferry, and so he tried to leave, but of course he was then faced with the other exit turnstile and asked to pay another penny. Mr. Robertson was quite upset at being required to pay twice when he didn't catch the ferry at all, so he complained, and his attention was directed to a nearby sign. A fare of 1 penny must be paid on entering or leaving the wharf. No exception will be made to this rule whether the passenger has travelled by ferry or not. The sign could be seen by passengers exiting the wharf, but not by those who were entering the wharf. Mr. Robertson refused to pay the 2nd penny, and the attendant refused to let him leave the wharf. After a bit of a struggle, Robertson eventually left without paying, and he actually sued the Balmain New Ferry Company in the torts of assault and false imprisonment. The court eventually decided that the sign was not reasonable notice, since it couldn't be seen by Mr. Robertson before he actually went through the first turnstile. But the court also pointed out that Mr. Robertson had caught the ferry many times in the past, and that he was therefore deemed to be aware of this particular term, and that it was therefore a term of the contract, because he had entered into this particular type of contract many times in the past. That's what we mean when we say that a term can be implied into the contract as a result of prior dealings. In addition to the terms implied by the court, there are also terms that may be implied into a contract as a result of legislation. A good example of this is the Sale of Goods Act, 1896. Queensland legislation, which is actually very similar to corresponding legislation in pretty much every state and territory in Australia. The Sale of Goods Act 1896 implies terms into a contract for the sale of goods that are intended to protect the interests of the buyer. A contract for the sale of goods is a very common type of contract. It's a contract where the seller transfers or agrees to transfer the ownership of goods to the buyer in return for a monetary price. So whenever you purchase anything for money, you are entering into the contract for the sale of goods. The Sale of Goods Act implies 5 main terms into all contracts for the sale of goods. The first is an implied condition that the seller has title, which simply means that it is implied into every contract for the sale of goods that the person selling the goods has the right to sell the goods, and that usually means that they are in fact the owner of the goods. If it turns out that the person selling the goods isn't entitled to sell them, perhaps because they're not really the owner of the goods, then they will automatically be in breach of the contract, because they have breached the implied term regarding title. There's also an implied term regarding description. It's an implied condition of every contract for the sale of goods that the goods will correspond with their description. if they are described in an advertisement, if they're described by the salesperson, if they're described by a nearby sign, if they're described on the packaging. There is an implied term in the contract that the goods themselves will actually comply with or correspond with that description. And if, for example, you buy a box of something at the supermarket, but when you open the box when you get home and it turns out that what's in the box doesn't match what's described on the box, then the seller will be automatically in breach of contract because they have breached the implied term that the goods will correspond with their description. There's also an implied condition that the goods will be of merchantable quality, and here merchantable quality simply means reasonable quality. There is an implied term that the goods will be fit for their purpose, provided, of course, that that intended purpose is either obvious or made known to the seller at the time of sale. And there is an implied term that the bulk of the goods will correspond with the sample. Whenever you buy anything in bulk, and rather than inspecting every single item that you're purchasing, you just look at a sample of the goods before making a decision whether or not to purchase them, there is an implied term that the bulk will correspond with the sample. And if, once you purchase the bulk of the goods, it turns out that the goods themselves don't actually match the sample that you were shown in terms of quality, then the seller will be in breach of the contract. In order to show that a seller has breached the statutory implied term regarding merchantable quality, 5 requirements have to be satisfied. The contract must be for the sale of goods. The buyer must have relied upon a description of the goods. It must be shown that the seller normally sells goods of that description, so that normally means that the goods were purchased from a business. The goods are not of merchantable quality, and the buyer has not examined the goods, or if they have examined the goods, the defect is not one that would have been revealed by the examination. If all 5 requirements are satisfied, then the seller will be in breach of contract. In order to show that a seller has breached the statutory implied term regarding fitness for purpose, there are 6 requirements. Firstly, the contract is for the sale of goods. Secondly, the seller normally sells goods of that description. Thirdly, the buyer has either expressly or by implication told the seller the purpose for which they were buying the goods. Fourthly, the buyer has relied on the seller's skill and judgment. Fifthly, the goods are not fit for the stated purpose. And sixthly, the buyer has not requested the particular goods by name. If all 6 requirements are satisfied, then the seller will have breached the implied term regarding fitness for purpose. Note that the requirement that the buyer tell the seller what the particular intended purpose of the goods is can be satisfied if the goods have a single or an obvious purpose. In Grant and Australian Knitting Mills from 1936, Dr. Grant purchased a set of woolen underwear that were sealed in a plastic bag from Australian Knitting Mills. When he got home, he put the underwear straight on, and unfortunately, due to trace chemicals in the underwear left over from the manufacturing process, Dr. Grant actually contacted dermatitis. Dr. Grant sued Australian Knitting Mills, arguing that the goods, the underpants, were clearly not fit for their purpose. Australian Knitting Mills tried to argue that Dr. Grant had not actually made his intended purpose expressly known to the seller, but of course Dr. Grant could not be expected to have told the seller what he was planning to do with the underwear. It was obvious that he would be wearing it under his clothes, next to his skin, so the court was satisfied that the intended purpose was known to the seller, that the requirements were satisfied, and that the seller had breached the implied term regarding fitness for purpose.